Today's date is, Today's date is Tuesday, March 15th, and we have a number of cases that we are going to hear arguments on today, one via Zoom and two in person. First case is case number 29994, Kiernan versus Ward. And as you can tell, your panel is Judge Hensel to my right, Judge Callahan to my left.
What are those C judges?
And I'll be presiding. Each party will have 15 minutes to present your arguments. The appellant, I should say, may reserve up to 5 minutes. If you let me know how much time that you would like to reserve, I will try to let you know, although now that we're in person, we have the timer up on the screen, so make sure you pay attention to that as well. The arguments are being recorded and posted on YouTube, so we ask that you stay at the podium, keep your voice up. If there are children involved in cases or victims, we ask that you not refer to them by their names, just by initials or otherwise. And Judge Callahan, Judge Hensel, and I have read the briefs in this matter, so we are prepared to proceed if you are. Would you like to reserve any time?
Yes, Your Honor, I would like to reserve 5 minutes.
5 minutes, okay.
May I remove my mask?
Sure.
May it please the court, my name is Attorney Rachel Pico, and I represent the appellant, defendant Jonathan Ward. The appellant has raised 3 assignments of error in this matter. First, that the trial court erred as a matter of law by utilizing different valuation dates for different assets of the parties. Second, that the trial court erred as a matter of law by valuing appellant's business as of 2013, 3 years prior to the date the parties filed for divorce and 6 years prior to the stated date of valuation by the trial court. Finally, the trial court erred as a matter of law in the calculation of its spousal support award and how it imputed income to the appellant. As the court is aware, this is the second time appellant has sought to appeal a decree of divorce issued by the trial court in this case. The salient facts therefore remain the same. Parties married on June 26, 1998 and had 4 children together. For most of their marriage, they resided in Virginia, but decided to move to Ohio around 2014. When the parties lived in Virginia, appellant operated Eclipse Lawn Care and a cash-only firewood business from his home. At that time, appellant had significantly more income, including cash. But when they moved to Ohio, the businesses were closed. The parties bought a home in Cuyahoga Falls with cash, and the parties and their children attempted to build a life together here. Unfortunately, the marriage didn't work. Appellant remained in Ohio with the children, and appellant moved back to Virginia to restart his business. Appellee officially filed her complaint for divorce on September 2nd, 2016. A trial was held October 11th, 2017, and the original decree was issued August 30th of 2018, which appellant appealed and was remanded back after the trial court failed to address several assets which needed to be corrected. On remand, the trial court held 2 hearings on December 11th, 2019 and January 14th, 2020, and issued 2 judgment entries on April 20th and April 21st of 2021, respectively. Although these decisions did address assets that had previously been overlooked, a thorough review revealed that the trial court still erred in rendering its decisions, at which point appellant filed this appeal. The first 2 issues before this court, while factually different, are based upon the same principles of law, and whether the trial court abused its discretion in utilizing different valuation dates for different assets, even though the trial court had explicitly stated it would use December 8th, 2019 for its valuation of all property. With regard to the first issue, the trial court used purchase prices for several depreciating assets, even though testimony and evidence were proffered to show these items in their condition as of December of 2019 were not worth what the parties had paid for them initially. For the second issue, the trial court used appellee's valuation figures for the appellant's business and related assets based solely upon appellee's testimony about their worth and income as of 2013, the last time she had been a bookkeeper for the business, even though the divorce itself was filed in 2016 and the stated valuation date was 6 years after 2013. While trial courts are granted full power and jurisdiction to equitably divide the property of married parties upon their divorce, Ohio Revised Code 3105-171B and C1 specifically provide that the trial court must make a determination as to what is marital and what is separate and divide such equitably. The rule in valuing marital assets and debts is that the trial court must use a specific date and must be consistent in the use of that date unless the trial court makes written findings of fact to justify deviating based upon an equitable reason. This has been held in Lynn v. Lynn and Mole v. Mole. Mole v. Mole further went to say that a party cannot pick and choose what dates to evaluate certain items of marital property, and the valuation should be determined as to a specific date, unless there is some specific reasoning provided by the trial court to deviate. In the instant case, the trial court erred in its valuation of the party's jet boat, 2 jet skis, a mini bike, 3 four-wheelers, and 12 go-karts by using purchase prices instead of valuing them as of December 8th, 2019. Each of these items of property are depreciating assets and begin to lose their value if they are not regularly maintained or improved upon. They were also purchased at varying dates throughout the party's marriage.
Counsel,
Yeah.
as to those items, it seems that what the trial court said in its entry was that it had 2 sides with 2 different values, and it simply didn't find one to be credible. Actually, it said that throughout the entry, as I'm sure you're quite aware. To what extent is this argument strong or not as strong because other valuations regarding depreciation and things that we know to be accurate weren't provided to the court?
We do believe that because appellant did challenge the purchase prices that were provided by the appellee, that it would have been more appropriate for the trial court to go into a more in-depth analysis as to why using purchase prices for depreciating assets in particular would have been more equitable. That's the standard under the law, is that there needs to be some basis in equity. Divorce courts are not only courts of law, they are courts of equity. When you deviate from the law, you need to base it in equity. That's our argument for that. I understand that there were what the trial court felt were credibility issues with regards to the appellant, but that was not gone further in depth, other than essentially to say that it seemed that the trial court did not appreciate the appellant and the appellant's testimony at various points, which we don't feel is a proper basis. With regard to the valuing of the equipment and appellant's business, there was a similar issue with regard to this. The last instance of the appellee being involved with the business was in 2013. Yes, she was a bookkeeper, and yes, she did have some understanding of what the equipment was at that time. However, the appellant had wound down the business in 2013 so that the parties could move to Ohio in 2014. This included selling some assets, and even later on, after he had separated from the appellee, he had been evicted from a property in Virginia. Multiple items of property, including the jet boat, jet ski, several pieces of equipment, were all sold at auction at that time. 21 pages of auction receipts were then provided by the trial court, and there was no true analysis provided as to those receipts and to their effect on things. In total, he only received $7,000 for all of the items that had been auctioned off, including $1,600 for the jet boat and jet skis, which the appellee had valued at $40,000. That is a significant difference, and that's where a big portion of the equitable argument comes in, and the issues that we have with the decisions rendered by the trial court. Given the nature of the appellant's business, the majority of the equipment used are also depreciating assets, so that is where this is also related. With regard to issue 3, or the final issue, the trial court erred and abused its discretion in how it imputed income to the appellant for the purposes of calculating support. Our argument is not that imputing income is de facto improper when calculating spousal support. Our argument is that there needed to be some finding whether the appellant was underemployed or unemployed prior to the court moving to impute income. Further, when the court did impute income, they imputed income to the gross receipts of the business. Even though appellee had been the bookkeeper, she would have known full well that the gross receipts does not equal the annual income of the business. Even most lay people would understand that. She also had no involvement with the appellant's business for more than 3 years after she filed for divorce, or for more than 3 years before she filed for divorce. And the trial court, in our view, arbitrarily accepted everything she testified to and claimed without properly considering appellant's testimony or documentation that was provided. Ultimately, the issue of imputing income to the appellant resulted in a very unequitable amount of spousal support. Specifically, he had been imputed to $215,253 for 2016, $225,666 for 2017, $202,543 for 2018. Again, pursuant to the tax returns, these were all of his gross receipts. There was no analysis conducted by the trial court to explain why only gross receipts were accepted. There was no finding of underemployed or unemployed. These were all concerns with regard to the credibility and the analysis done by the trial court. The expenses filed by the appellant were ones that were included on his tax return that had been analyzed by his CPA and accepted as appropriate expenses, particularly taking into consideration the fact that the appellant had sustained personal injuries, which resulted in a personal injury settlement that was one of the issues on remand last time. It would be completely understandable that he would have certain expenses such as contract labor. Owning and operating some kind of a landscaping or lawn care business is very labor intensive. He was physically unable to do that. That's why the contract labor costs increased over time, and that's also why he testified to that at the trial. However, in looking over the analysis done by the trial court, there was actually really no analysis done. There's no consideration of this. Instead, it seemed as though it was more of a punitive decision to accept all gross receipts without taking into consideration anything else proffered or testified to by the appellant.
Reserve that 5 minutes or continue?
Yes.
All right, you'll have 5 minutes for rebuttal.
Thank you.
All right, Attorney Erb, you will have 15 minutes.
Thank you. Good morning, Your Honors. Attorney Erb on behalf of Appellate, Melissa Kiernan. Your Honors, I would submit the salient facts of this case were not the same as the first time this trial was held. There was 2 additional days of trial held after the initial trial. The court examined all the facts and circumstances of this case, and they came to a conclusion very similar to the first time. In fact, the court noted many times that the appellant was not a credible witness, and he was evasive in his answers. He couldn't even identify the date that the divorce had been filed. He indicated debatable. As we all know, the trial court is in position best to assess the credibility of the witnesses and determine whether or not they are credible or not. In fact, the court gave appellant additional time to submit his exhibits for his business prior to the second hearing. Appellant didn't take that opportunity to produce those exhibits. Many of the cases that appellant cites to are from the 3rd District Court of Appeals. I believe that White is more applicable to this case, which was from the 9th, in terms of what the judge determines and the dates the court determines to use. The trial court found my client, the appellee, credible, and her testimony credible. She testified there was large amounts of cash, they had a wood business, they had the lawn care business. There was potentially more income than even the $200,000 that she imputed to defendant. Defendant indicated at the trial that he sold vast majorities of the equipment at this auction, and yet on cross-examination in the trial, the court found and admitted pictures of items that the defendant indicated he had auctioned and yet still possessed. As to the spousal support determination and their contention, they have to be legitimate business expenses. The court imputed income to both parties, not just to the appellant. The court imputed the appellee with $29,125 approximately of income when my client was making far less income at that time. As we all know, not all deductions that the IRS deems to be and takes are eligible for gross income purposes for the purposes of the calculation of child support. They have to be ordinary and necessary business expenses. And the party claiming these expenses has the burden of proving to the trial court that they are ordinary and necessary business expenses. And the appellant failed to carry that burden. The trial court mentioned this many times, that the lack of documentation that the appellant brought before the court to try and sort this out. I would also note that the court is not required to go out and do the work for the parties. This trial, if you read the transcripts, the judge had to inquire of both parties to quite an extent to try and figure out the facts and the circumstances of this case. My client represented herself at the two second days of trial, and Mr. Ward was represented by Ms. Six. And the court heard the testimony from both parties as to the valuations. Both parties had the opportunity to get the appraisals done. Both parties had the opportunity to do depreciation calculations and present this evidence to the court with some sort of experts or not. It wasn't done.
Counsel?
Yes.
Excuse me, I'm sorry. Regarding that, and I'm going to maybe flip the question a little bit, what I asked the opposing counsel earlier. And you're right, and the court's frustration in not having some of these values presented was also pretty apparent in reading the journal entry. But in terms of some of these personal items, the jet skis and the things that are mentioned here, even without other values being provided, and I know that husband testified as to value, which was discounted for credibility reasons according to the trial court. But wouldn't, if you apply equity, wouldn't common sense tell you that new purchase value is no longer the value?
Well, I would think, Your Honor, that the judge had a choice to make during that trial. Based on what was in front of her, she had to make a decision. And to apply something other than the testimony, I'm sure we would be up here discussing if she picked a random valuation of the items with no evidence in front of her. The only evidence she had in front of her was the testimony of the appellant and the appellee. So yes, common sense would dictate that the valuation's probably not $40,000, or the valuation's probably not $1,000. But left in her the trial court's sound discretion, she had to pick a number. And the number she picked was based off the plaintiff's testimony, which she found to be credible, and she found the defense not to be credible. So I do believe that if the court were to just say that $40,000 was $20,000, that would then itself present a different problem, because that wasn't evidence in front of her. Again, neither party submitted any evidence in this case as to what the valuations of these items really were. Both parties had that opportunity.
Did she pick something a little different from the testimony? Still within the boundaries, but a little different with regard to the business asset?
Did she or could she?
Did she?
I think in regards to the business, again, his responsibility was to show the court what his business was worth. I cited a case from this court. I've dealt with many self-employed people over the years. What they claim as actual income is generally not what their real income actually is. And as I said earlier, ordinary and necessary business expenses, as defined in the Ohio Revised Code, is not the same as what the IRS will accept. For instance, you could deduct a jacket or clothes that you purchased for your company, but I don't believe that those would be permissible in a spousal or child support case as an ordinary and necessary business expense. In addition, you could have had a CPA show up and testify to any of this information, bring the receipts with him. The the appellant generally just disclaimed any responsibility for having any exhibits there whatsoever. In fact, I think at one point he referenced, I'll have to go and look at the receipts. This case has been pending 4 years. 4 years when he showed up to testify. He had 4 years to gather these documents, 4 years to put everything together. He knew he was going to be in court that day. He failed to do so. That's on him. That's on him. He had the responsibility for doing it. Both the case law and the Ohio Revised Code clearly lays all of this out, and he didn't do it. And in addition to not having those receipts, she found most of his testimony to be not credible. Addition, I think I read the case differently than the appellant in terms of whether the court can impute income to the appellant or not. I think the court can impute the appellant income. It's a consideration the court can take into account, not a fact-finding pattern. So for all of these reasons, Your Honor, we believe that the Judge Cook made the correct decision in this case. We would ask the court to uphold it. Thank you.
All right, thank you, Attorney Erb. And counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. regard to some of the statements made by opposing counsel, I did want to point out a few things. I do understand that in the decisions rendered by the trial court, it did appear in her evaluation that the appellant had been slightly flippant in some of his comments and answers to questions. With regard to the date of filing for divorce, and when he said debatable, it was because he had also filed for divorce in Virginia, so there were competing motions. The parties actually did receive a technical date of divorce from the Virginia court prior to the date of divorce in Ohio. Of course, Ohio had the personal jurisdiction to handle the property award, so that is part of why we're here today. I didn't feel that it was necessary for me to bring up the Virginia case and that they had a technical date of divorce in that Commonwealth, but I did want to point that out with regard to his testimony in that. With regard to the reason why we're here today, we're not arguing that the trial court is incapable of choosing different valuations or that they are incapable or it's improper for them to impute income. Instead, what we're arguing is that the trial court did not do a proper analysis. They did not weigh all testimony, they did not weigh all documentation and all evidence properly before assigning values to items, especially items of depreciating natures, and vacillating wildly between what the stated valuation date was of December 8th, 2019, and then going back to 2013, or going back to different dates throughout the parties' long marriage, where they're choosing purchase prices for items. There was testimony provided that contradicted different purchase prices, such as the jet boat and the jet skis. Appellate said that that was for $40,000. Appellant testified that they had bought those items used for $12,500. There should have been an analysis done of all of this. Like I stated before, domestic relations courts are not only courts of law, they're courts of equity. The court is going to deviate from what it has already stated it's going to do, such as valuing assets as of December 8th, 2019. It needs to provide an analysis, it needs to provide that basis in equity, and to make that decision based upon all factors that have been provided, showing all parties that everything provided to the court have been considered. The court can then, at that point, state that certain things they don't feel might be equitable or might be, credible, or might not have the sufficient weight to rely upon. That would be understandable. I would not be standing here today had that been what the trial court did. That's not what happened here. The point is essentially that the trial court has not weighed all factors provided to them, both for the income and for the property of the parties. We feel that as a result, what was issued by the court was essentially arbitrary in its basis and unreasonable in the figures that were used.
Counsel, I probably should have asked this question before. However, I noticed that the court found that your client committed financial misconduct, and then perhaps utilized that finding when making the distributions as it relates to assets, also though perhaps as it relates to income, whether that's an imputed finding as it's stated or whether that was the actual finding. That's just what I think this person makes. How does that finding of financial misconduct factor into what was the end result?
So I think that how it factors in might be a question more for the trial court, because that reasoning was not fully thought out or stated in the journal entries that we did ultimately receive. With regard to the comments about financial misconduct, again, that's not well reasoned within the decisions that were rendered, whether that was back in 2018 or in the decisions in 2021. This is all part of the problem here, is that we're not getting a basis for it. Instead, the way that it essentially reads or has read to the appellant is more that some of these decisions were done punitively without making well-reasoned arguments or making well-reasoned findings as to why the appellant was, as you described, guilty of financial misconduct. That's not fully analyzed. Had it been, the appellant committed financial misconduct for X reason in X way at X time, that would be different. But it seemed to be more of, I don't want to say personal views, but without knowing more of what the trial court's reasoning was for that. And at the same time, too, we would note that at the 2017 trial, the appellant was unrepresented. He had gone without counsel for that trial. He was represented for the 2019 and 2020 trials on remand.
Thank you.
I think I'm over time, sorry.
I want to thank you both for your arguments this morning. Clearly, the court will take this matter under advisement. We'll issue a decision in due course. Each of you will be mailed a copy of the decision on the day it's released. And as you probably know, you can check the Ohio Supreme Court's website, which posts our opinions. Thank you again for coming down and arguing today.
Thank you, Your Honor.
Thank you, Your Honor.